Hello everyone, thanks for tuning back into my channel. Today is going to be an interview that we did the other day with Barbara. She is an estate planning attorney, and we are talking about the consequences of probate and the benefits of having a living trust. So make sure you stay tuned. It's a great interactive interview. You're going to get a lot of wealth of information. If you are a homeowner, plan to be a homeowner, this video is for you. All right guys, stay tuned. So everybody, this is Barbara Bergstein. She is an attorney who specializes in probates, living trusts, and even trusts for minor children and young adults. Yeah, Barbara?
Children with special needs.
Children with special needs. That's awesome.
A lot of the families in my practice, have children with special needs.
Awesome. So tell us a little bit about yourself real quick. How long you've been in the business? Anything special that you want our audience to know?
So I've been practicing for 28 years, almost 29 years. I used to have two law partners. We were together for 15 years. And then I went my way, they went their way, but I've lectured all over the country. I lectured for the CPA Foundation, and I lectured for the continuing education of the bar. And I've served on various committees and tax committees. I was on the State Bar Gift and Tax Subcommittee. And I've written a lot of articles. I have an article on estate planning for children with special needs that appeared in the October 2020 Valley Lawyer. So I've been published and I've spoken all over.
Yay, I love it. I love it. So how I want to break this down is I want to keep this to about 45 minutes, maybe an hour tops. I want to respect everybody's time because I know time is important for everybody. I want to talk first about probate. Then we'll kind of move into the living trust. Anybody who has any questions, use the chat button down below to log your questions in, and then we'll go through them. Or at the end, we can raise hands or unmute yourself to ask Barbara any questions that we might have that we didn't get covered today here. So make sure you guys keep yourself muted as possible, and then put the chats down below or raise your hand, and we'll get to you guys after that. So Barbara, let's talk about probate. For those of us, I know we all hear the word, but what is probate? What does that mean?
It is a court supervised proceeding to administer someone's estate after they die, and they either have a will or no will, because even if you have a will and you don't have a living trust, you're going to potentially go through probate, especially if you own real property. There is no way to transfer title to your heirs or your intended beneficiaries unless you get a court order, and then you record the court order with the title company. So it's very important to either make a will so that your beneficiaries are known, because if you don't, everybody thinks if you don't have a will, it goes to the state. That never happens. There is the Law of Intestate Succession, which says if you don't say to whom you are going to leave your estate, the natural order would be to your children. If you don't have children, then it goes back up to your parents. If you don't have parents, it goes to brothers and sisters, nieces and nephews, cousins. So every state has an intestate, meaning you die without a will, flow chart of who inherits your estate if you don't say it. So one, if you don't have a will or a trust, the states are going to decide who gets your assets. It's going to be costly because there's filing fees, there's publication fees. You have to publish a notice to creditors, and it has to run for 4 months. The creditors have 4 months to come in and file a claim against the estate. You have a probate appraiser that is appointed by the court who takes 1% of the appraised value of the assets. And attorney's fees and executors' fees are based on a decreasing value. It's like 4% of the first 100,000, 3% of the next 100,000, 2% up to 800,000. So attorney's fees get very high. It's costly.
So Barbara, you're answering all my questions so fast that we're going to be done in 10 minutes. So slow down a little bit, because I know that everybody here kind of wants to get this information going. So probate, one, is, God forbid, somebody who passed away without a will or without the ability to convey or transfer title through the normal means of like a grant deed and stuff like that. And now the courts have to step in and handle the transfer of the asset to either their family or to be sold. Correct?
Yes.
So does probate only apply to real estate?
No. It applies to bank accounts, investment accounts, and it can be, we have something in California called the small estate set aside. So if the only thing you have is, let's say, a bank account that has $10,000 and another bank account that has $15,000, you don't have to probate it. If the total value of assets are under $166,250, you can collect those accounts by affidavit. You don't have to go to probate.
Interesting. Gotcha. So, and then in probate, who becomes in charge of the probate? How do they figure out I'm in charge? Do people fight over things like that? Or,
well, if you have a will, you name an executor. You say, this is the person that I want to administer my estate. If you don't have a will, somebody has to file a petition saying, hey, my mom just died. I have all these assets and the bank won't let me do anything. And the investment company won't let me do anything. And I can't get into her safe deposit box. So somebody has to come forward, file a petition for probate to be appointed administrator. An administrator means there's no will. An executor means there is a will.
Got you. So if somebody passes away and let's say I want to step in on behalf of a family member, I file to be an administrator of the estate. And I'm assuming other family members have the right to raise their hand and say, yes, we want Tom, or no, we don't want Tom.
That's right. They can file an objection.
Got you. And all of that could be time and money.
Yes, and you have to post a bond.
And
in a will, you can waive the bond. You can say, I authorize my executor to serve without bond. That means you have to post with a surety company. They have to say, Tom, tell me what your assets are. Because if you run off with all the estate assets, because now you have control of them, we want to be able to come after you. So the bonding company will reimburse the estate. And then they're going to go after Tom and say, Tom, we want that money back.
Wow. Okay. So when you're now, can that administrator, does he get paid? Can he charge a fee?
He charges he gets the same fee that the attorney gets.
Wow. Okay. Good to know. And then I know you touched on fees a little bit early, but I'd like you to kind of retouch that. What kind of fees are associated with probate? You said something about a scaling down number or something like that. Tell us a little bit more on that.
It's a decreasing percentage of the value of the estate. So it's 4% of the first $100,000 of value, 3% of the next 100, 2% of the next 800,000. It goes up to 0.25% up to 15 million. So look at the Michael Jackson estate. Okay, Michael Jackson's probate is still open. By the way, you should also know that Michael Jackson had a living trust.
So not all of his assets were put into that trust, and those things that weren't in his trust went to probate.
That's it.
Wow.
Including, I believe, the Beatles. He owned all the catalog to the Beatles.
I remember that, yeah.
And I have a hunch that wasn't assigned into his trust. He died in 2009, and that probate is still open.
Wow. So when you talk about this scaling, the attorney gets that scale and the administrator can get that scale.
Same thing.
So that's money that could have been to the heirs or family members or things like that. That's just really kind of going out there. Now, I'm sure the administrator could probably waive his fee, if you want to be a good family member, but.
Right. Usually if it's a family member, they waive it. But remember, it's also income taxable.
Oh, wow. Okay. So what if nobody wants to be the administrator?
There is a public guardian's office, and the public guardian would take over.
Gotcha. And I'm sure he wants his scaling fee there.
Well, the county of LA sure does, yeah.
Gotcha. That's great stuff. What about the creditors in a probate? Do they have a claim to all of this?
Yeah, so there's a 4-month creditors claim period. When you publish, remember, one of the things you have to do is publish in a newspaper of general circulation. And creditors come in and they can file a creditor's claim against the estate, especially if someone was receiving Medi-Cal. If you were in a nursing home when you died and you were on Medi-Cal, the state is going to come in. I've seen hundreds and hundreds of thousands of dollars of Medi-Cal claims.
Wow. So are these like car loan people? We had 3 cars and stuff like that. They're all
Could be anybody.
Could be anybody.
So you have to keep the estate open for 4 months. That's the statutory creditors claim period. After 4 months, you can close the estate.
Wow. So for 4 months, this person's assets are just dwindling away because I'm sure interest is being charged on all these accounts and balances and stuff like that just keep going up and up and up while all this stuff is happening. Yeah.
You have to hold everything in an interest-bearing account.
Okay.
So when you're the administrator or executor, you have a fiduciary duty to take those assets and put it into an interest-bearing account. That's what you must do. Now, if it's a brokerage account, you're going to leave it and you're going to hope that that account makes money during the term of the probate.
Gotcha.
If there's real estate, sometimes now you know, Tom, you can have an open bidding in a courtroom. So somebody says, I want to buy that property, Tom. And you say, okay, we're going to go to court because there's a probate. 10 other people can come in and there can be an overbid.
Yep. I have a question on that to make sure I touch base on here on my notes as well. So the court's main role then is really to facilitate this whole orchestration. Is that what the courts do? They one, obviously convey title to whoever is going to be the owner of this property in probate, but they also oversee the distribution of these assets to the creditors and to the heirs and things that are left over. That's kind of the court's main role on this?
Yes, but you can also have a lot of independence. There is something called the Independent Administration of Estates Act. So we check a box on the probate petition that says we want to be able to administer the estate with less court involvement. Nobody objects. You can pretty much go about your business, even sell real property without the court's authority. You don't have to have a sale go through the court.
Gotcha. Interesting. Good to know. Let's take a step back and talk about this will. How important is it minimum to have a will at any age, or does it, do I have to have a certain amount of assets? Can it be on a piece of paper? Tell me a little bit about a will.
So a will, yes, a will can be formally drafted by an attorney. Some people go online and do a will. I don't recommend it. The good thing about a will versus not a will is that you get to say where your assets are going, rather than going to the laws of intestacy, where I said earlier, every state says to your kids, then your parents, then your brothers and sisters. So you get to say, you might want to leave your whole estate to a charity. So you can write a will on a napkin, and it's called a holographic will. It has to be completely written in your own handwriting. No witnesses. A formally drafted will must be witnessed by at least 2 people, not related to you.
Do any language have to be in that will? You always hear about of sound body and mind or something like that. Do I have to put all that stuff in there?
I, Tom Hernandez, this is my last will. This is what I want. I want my executor to serve without bond. If in a will you say my executor gets to serve without bond, then there's no surety company involved. That's another plus, save some estate money. Gotcha. So yeah, you can write a will, but don't type it on a computer. If you do that, then you got to have 2 witnesses. It must be written entirely in your own handwriting. Gotcha. Now, there's been some funny cases that somebody took a piece of stationery in a hotel room. And of course, the hotel had its name on the top. And then somebody said, this is my will. Is that written entirely in the testator's own handwriting? And there have been cases like that. Well, there was printed material on the top. It makes for fascinating reading.
I love it. Now, is there anything that makes a will? Do I have to sign it to make it valid?
Yeah, sign it and date it.
Sign it. So signing and dating a will makes it valid. Do I have to rush down and file it with the courts, or can I keep that in my back pocket or in my gym bag or in a safe? And
I hope you keep it in the safe.
yeah, gotcha. Sounds good.
However, when someone dies, the family or the executor or the administrator has a duty to send the original down to the Superior Court in Los Angeles for safekeeping. You can keep a copy, but you always want the original will. If you can't find the original will, it's harder to get it admitted to probate. Then you have to go find the people that witnessed the will and say, yes, I remember signing it. Yes, this is his handwriting. Yes, I saw him sign it. So you have to have the original will.
Gotcha. And then if there is no will, we're back to that whole square one of what we just talked about. Yeah.
Yeah, we're in intestacy.
Got you. Now, you mentioned about a bond. Just what that bond is to ensure me as the administrator.
It's to ensure
that I
that
won't
if you
take the
run
money
away,
and run away.
if you take the estate assets and go on a cruise, then the bonding company will reimburse the estate for the amount that you took and track you down to get it back.
Gotcha.
So it's a surety bond.
Gotcha. And then when we talk about time, minimum 4 months.
Have to keep it open from 4 months from the date the clerk of the court stamps the letters of administration or the letters testamentary. It's not the day of the court hearing, and it's not the date that the judge signs the order. It's the date that the stamp is put on the piece of paper that says you're the executor. 4 months from that date is the creditor's claim period.
Got you. Wow. So that, I mean, that's what some of the shocking stuff that I was thinking about was, like, man, you're in limbo for such a long time, and, time is money and stuff like that. So yeah, let's talk about, the court confirmation versus non-court confirmation. Why do we hear that? I hear that all the time in the MLS. Court confirmation required, no court confirmation required. Why? What's the flip-flop on that?
That's the box about the independent of estate administration, where you've been appointed the executor or the administrator, and you've asked, or your attorneys check the box that says, we want independent administration of estates, meaning you pretty much go your way, do your thing, and the court doesn't stick their head in. But your bond is going to be higher for that. To the extent you want your bond premium to be lower, maybe you want court supervision, because then you're not at risk of running off. They're kind of looking over your shoulder more.
So as a real estate agent, if I see that thing that says subject to court confirmation, guaranteed they didn't check that box.
That's right.
And the reason might be...
Or when they filed the petition for confirmation of sale, they're saying, we want you, if they file that petition, that form, it's called a petition for confirmation of sale of real property. That's a form. That's saying, okay, I want this sale to happen in court, even if you do have independent estates rights. So it might mean they didn't check the box, Tom, but it might mean that they did, and they just want overbids.
Got you. Interesting. Because we always see that. And then, our clients, we ask them, I don't know, they need court confirmation. So it's great to know a little bit behind the scenes. Thank you so much for sharing on that. Last question on this is going to be family. Like, my dad died and I'm the one that's in charge. And I'm his brother and I'm in charge. What happens all there in probate? I'm sure that's kind of the norm.
There's a fight. Somebody shows up on the date of the hearing to approve the will, and someone objects and says, no, he wouldn't have wanted his son to be the person. I'm his brother. I knew him better. And then you get into a fight. Who's going to be the administrator? Who's going to be the executor? Well, it wouldn't be the executor, because if there was a will, the will would name the person to serve. So usually if there's an argument, usually it's because there is no will.
Interesting. Okay, so and that happens within that 4 month period or after that 4 month period?
No. Before the 4 month period, before anything ever happens.
Okay.
Before a person is even approved, the first step is who's going to administer the estate. So if on the date of the hearing, 3 people show up, the judge is going to say, come back when you decide, or everybody submit paperwork why you should be appointed.
Interesting. So that could be a 60-day battle. And then we finally get to that stamp process that you said, now I got 4 months. So there's 6 months down the line before we get any type of settlement going on over there.
Yeah.
Got you. So I guess the big takeaways, it's time consuming. Your dirty laundry of all the people that you owe gets aired out to everybody in a 4-month hearing. And I guess what else would be a big takeaway?
There's no privacy.
There's no privacy.
Anybody could go down to the courthouse, pull a file and look at it. It's public record.
Gotcha. So now let's move into the living trust part of it and why that is kind of the big ticket in protecting us from all that stuff. You know, what is a living trust and its benefits?
So a living trust is a revocable trust, and how it differs from a will and a probate is, number one, it's private. It's not of record anywhere. It doesn't get recorded. It holds your assets during your lifetime through the transfer of assets into the trust. What is a trust? I used to bring my son's Monopoly game into my client meetings. And if you think of your trust like a shoebox and you take the lid off and you throw in Boardwalk and Park Place and the little hotels and you throw in some cash and maybe that's your investment account or your bank account. And you could throw in personal property. Maybe you throw in, you know, the shoe. Remember the shoe? You throw in all that stuff. And now you've built a wall around your assets. So there's no need for a probate. Now, every once in a while, my clients don't listen to me. And they don't put that $300,000 Bank of America bank account in the trust. They die. And now I have to go to the probate court to get it in.
Gotcha. So a living trust is definitely, now the word living is because I'm alive during this time?
It's because yes, and it's amendable. It can be amended all through your lifetime. It can be changed.
Got you. So a living trust versus a will. Will's kind of like, hey, this is what I want done after I'm gone. And the living trust is, hey, I'm alive and this is how I want to protect my assets. And I want to throw these things in for future protection down the road for my heirs.
And when I die, this is to whom I want my assets to go.
Got you. So
privacy.
Does the living trust get filed with the courts as well?
No, it never gets recorded or filed anywhere.
Got you. So I guess when you have a living trust, there's no interaction with courts then? No.
Well, trust litigators, the probate litigators make a lot of money over trust contests. There's will contests, there's trust contests. So believe me, I put in these long no contest clauses. That does not stop somebody from still filing a suit at the end of the day. There's always fights. One kid got more than the other kid and they're disgruntled. You hope that it just unfolds the way that the person wanted it to, but not always. I'm working on a big trust administration right now. I've been working on it all day. When someone dies, you have to send notices to all the trust beneficiaries with a copy of the trust and every amendment. They have a right to see it. So there's work. It's just not with the court.
So personal information is protected. It's not made public. Your assets, how are they protected? Because you kind of throw them in that shoebox, like you said.
But a living trust does not provide creditor protection. Your assets are still subject to creditors as though you had never had the trust, because you are the trust. The only way to protect yourself from creditors would be an irrevocable trust. And an irrevocable trust by term is not amendable, not subject to amendment. So that's why, and then there are tax consequences for giving up your assets and putting them into an irrevocable trust. I do want to say that a living trust does not change taxable events. It does not change the estate tax. You still may have to pay estate taxes. Your income taxes are the same. It doesn't change that.
You just made me think of something, and I'm going totally off topic on my notes, but when you talk about irrevocable trusts and you're saying it can't be amended, is there a certain lifespan in our lives that would be appropriate? Like, Tom, you're in your 40s and 50s, you're too young, but Tom, you're 90. Now's the time that a revocable trust might be beneficial, or what would be a good...
It has to usually do with the value of your estate, and it has to do with avoiding estate taxes. So people set up irrevocable trusts to remove appreciating assets from their estate. Let's say you have a client that owns an apartment building and it's really appreciated in value. And now his or her estate exceeds the federal estate tax limit, how much you can give away at death without paying a death tax. We sometimes put them into what we call irrevocable grantor trusts. We remove the value from the estate, but we allow the creator of that trust to keep the income. So they're called grantor trusts for income tax purposes, but for federal estate tax purposes, we've removed that asset from the taxable estate. But right now, the amount that each person can give away tax-free during lifetime or death is $11,700,000. So unless your estate is greater than that, I don't think you might need one.
From your lips to God's ears, our
That would
estate
be
one
nice.
time in our lifetime will all be that.
But that law is going to sunset in 2025, and it's going to go back to maybe 5 million a person.
Oh, wow.
That's a big difference.
Yeah, yeah. So I know you specialize in minor children and young children with disabilities. What are some benefits by setting up something like that for anybody that might have people like that?
So a child with a disability who never can work in the workplace, who has severe limitations at age 18, probably is eligible for Supplemental Security Income, SSI, and Medi-Cal. And those are means-tested benefits. The person can't have more than $2,000, and they can have very little income. So what parents often do is they say, on my death, I'm going to create a special needs trust. And I want my assets to go into that special needs trust because I can still allow my child to get the medical insurance. SSI pays for food and shelter, but I can give my child a better lifestyle if I leave him or her some money. So the special needs trust maintains government benefits and provides an extra supplemental fund to make that child's life better. Got it.
Now let's talk about business. I have a couple of LLCs. I might have some partnerships. Am I able to throw that stuff into my shoebox as well? Am I protected in a living trust? Is that something that I want to put into my trust, my LLC? Yeah. Or
you do. I've set up LLCs, and what we do, unlike a corporation that has corporate shares, an LLC has unit shares. So I do an assignment of unit shares into your trust so that if something happens to you, that underlying asset, let's say there's a building in the LLC, I want that underlying asset to be part of your estate. Otherwise, I'm going to have to probate it. Just a simple assignment.
Gotcha. So definitely want to make sure that you have your LLCs, any partnerships or stuff like that. And then, of course, your real estate.
Yes.
Now, when we talk about putting that stuff into a trust for real estate, I know it's actually recording a document that says, hey, this is going from Tom Hernandez, an unmarried man, to the Tom Hernandez Living Trust dated 2020,
That's right. That's
whatever.
Right. That's right.
Partnerships, kind of, it's just written out in the trust that I have the TMH Financial Network LLC, and
that's right.
I own 50%, and my 50% is deeded to this trust.
But we don't deed it. We
not deed it, but assign it.
So there's two ways that I do it. Attached to every trust is a schedule of assets, and I list all of your assets. In addition to doing assignments, because there is a famous case in California that says, if you list the assets on a schedule attached to the trust, whether you transfer that asset by formal title or not, it's deemed part of the trust. So I don't have to do a full probate. I can go to court and say, it's called a Hegstad petition. Hey, When Tom did that trust, he listed that asset on the schedule of assets, and therefore it is part of the trust. It's a court order confirming, but it is not a full probate. It's a one morning hearing.
Interesting. What about personal property, like gold, jewelry, my Xbox, something of real value that I got there,
Yep, all of that is, well, I have a clause in the trust that talks about tangible personal property. A lot of people will say, I want my wedding ring to go to my daughter. I want my Lakers memorabilia to go to my son.
Gotcha. So definitely want to throw all. Now, I mean, what happens if I didn't put that in there? Is that's going to go to the yard sale or?
No, because I won't let you.
I love it. I love it. Gotcha.
Because I also do a piece of paper called the grant and assignment, and that is a general assignment of everything going into your trust.
Okay.
So I always do a grant and assignment, and that again keeps you out of probate. That one document, you could say to the court, look, Tom signed this. He said, everything I own now or hereinafter acquire, whether formally transferred or not, is in my trust.
When we talked last week, and you mentioned something that just, man, has been ringing in my ears, and I have it in bold here on my notes, and it was talking about, you mentioned that people fail to fund their living trust. And it just sounded kind of weird. And I asked you, and share us what you mean by funding the living trust.
I do every deed of real property into the trust. I never would allow my clients to do a deed. Never. I mean, I do them, I record them, I send them down to the LA County Recorder's Office, FedEx with a return FedEx envelope. So I know that that document's been recorded. I then also do a closing letter and I say, look, here's what you do. Here's every account that's listed on the last page of your trust. And I literally embed it into the letter. I say, go to that institution with the certificate of trust, which is a summary of your trust, and put it in the name of the trust. I can't do that because I'm not them.
So that means that if I have a Chase account, I'm literally walking into Chase and saying, hey, that savings account that I have with 50,000 on, I want to now change it into my trust.
Yes.
Got you. So that way those assets now are all protected. And you're saying that that's one of the big mistakes, or one of the big things that a lot of people fail to do, is to put their money accounts into their trust.
And life insurance. Because if you have families with small kids or not so small kids and they have life insurance policies, instead of naming the spouse and then your children, name the trust as the first beneficiary, so that if there is a common accident, the parents die, the money goes into trust for the minor children, and then the trust will say, hey, don't give my kids the money till they're 30. Okay, then the insurance money is in the trust and helps fund the kids' trust. Life insurance policies, big issue, should be naming the living trust as the beneficiary. Got
you. So I know the big question that I have here that everybody wants to know is, how much does it cost to set up a living trust?
Well, I'm just going to give you some generals.
Sure, please. I'm sure it's case by case, but
it is
on the general.
Generally, well, first of all, when you do a living trust, that's not the only document. There is all of these assignments that I do. There's the deed. There is the certificate of trust. There is a durable power of attorney for financial matter. There is an advanced healthcare directive. The pour-over will, unlike a will that throws you into probate, the pour-over will says, hey, if I don't transfer that Bank of America account into my trust, the court will do it for me through my will. But as I've told you, given the kind of documents I draft, I bypass that too. But it is many documents. I have lawyers that are my clients. Only another lawyer can unwind a law practice. Only a psychotherapist can unwind another psychotherapist practice. So I have to do a limited power of attorney for psychotherapy practice or law practice. There are corporations. I want to assign the corporate shares to the trust. So when you say a living trust, you have to know that an estate plan is many documents. So I'm just going to give you averages
Sure, please. That's
for a
what we're looking
single
for.
person. And again, we're not just talking about one document. We're looking at a roughly $2,000, maybe $2,500 if I have to throw in a special needs trust, because that's extra drafting for me.
Gotcha.
A married couple, depending if I divide the estate on the first death into sub-trusts, because I tell young clients, look, if your husband remarries and the casserole ladies are knocking at the door, you don't want him maybe to have control of all of the estate. Maybe we're going to say on if wife dies first or husband dies first, half goes into a sub-trust, half goes into another trust. There's a lot of thought that has to go into this. So I'm going to say a married couple somewhere around $3,000, $3,500.
Okay.
But that's just an average.
Gotcha.
The biggest
Gotcha.
estate plan I ever did was $20,000.
Woo. Interesting.
Lots of irrevocable trusts.
Gotcha. But I mean, just for the general, the norm, the common,
Yeah, that's
somewhere
like an
between
average.
$2,500 and $3,500.
And
What kind of?
2,000.
So everybody on this phone, on this Zoom here, they all hang up and they're like, Barbara, I want to see you tomorrow. What do I bring? My driver's license and my
No, I
checkbook
want to
account,
listen.
or
We're going to meet and we're going to talk about your assets. And here's my problem. And I said this to you, Tom. Everybody says, well, how fast can you get this done? And I go, I'll work as fast as you let me work. Because I write 5-page letters to every client explaining every document and what we talked about at the meeting. Then there's a retainer agreement, and I send a client intake sheet that helps me draft each document. Who do you want to leave your assets to? Who's going to be the trustee and manage your trust if you can't? And people sit on it and they don't bring everything back. I can't tell you how many packets I have out there. People are just don't return them.
gotcha. But ideally, it's nothing really out of that I need to show up with a big laundry list of items. It's more of like a consultation with you.
I never charge for the consultation,
Okay.
ever. I never have. And I also wanted to say that I have had, single moms, single dads come in. They're struggling. They might have a special needs kid. I will always reduce my fees if they are in a hard situation. I always have.
I love it. Well, that's why we picked you, Barbara. So good to know about that. Time period to create it really is how
I've
fast.
done one in 2 weeks. One of my best clients this year was a couple that had a trust, but they did it online. They tried to do their own. I said, look, I'm going to amend and restate this. I sent the letter out. They returned it within 2 days. I drafted their estate plan. They went through it immediately. And by the end of the following week, they signed. They were like the star clients ever.
All right. So we want to be a star 2 weeks. That's the record.
Well, then I send packets out and I send the drafts.
Gotcha.
When I send drafts, I do more detailed letters and I tell them section by section, which each document, what it says. And I highlight it. 6 months can go by and they don't come in to sign.
Interesting. So I have a question here, but I think you might have answered it. And I wrote, does a living trust protect us from creditors? And it really doesn't. It doesn't protect us from the people that we owe. We're still going to owe them. I'm still going to go IRS owe them for whatever money that I earned and stuff like that. It's just a way of keeping somebody not in charge of what I want to get done. And it's a way to kind of protect it there. And I also wrote, does a living trust avoid taxes? So taxes and creditors, they're both going to be there. You said the only possible way to maybe do something like that is with an irrevocable trust, right?
Yes.
Got you. Now, you mentioned about your friends, the 2-weekers, and they used an online. And I have a question. Why use an attorney versus Legalzoom or something like that? I can go on for $3.99 and
yeah, you can, and you can go to a trust mill and paralegals will do it. And somebody has come in and I'll say, I won't touch them. They say, oh, I want to amend this because I go, I will not touch or amend a document that was not created by an attorney. It's too risky. I said, if you want to work with me, I will amend and restate it, meaning I will give you an entirely new trust document. Name stays the same. If your assets are in there, you don't have to retransfer them, but I'm going to give you a legal document that works.
Yeah, I can tell you firsthand, when I was younger, I set up an LLC and I did LegalZoom, and I thought I was the man. And there were so many missed things in there that had I would have done that, I would have saved me and the partners a lot of money. And I vowed never again would I go to, it's kind of like going to a discount brokerage, you get what you pay for.
Yeah, I've
Stuff like
seen,
that. But I just,
some of them aren't bad. I've seen some pretty good, actually, I have seen some pretty good durable powers of attorney online. But here's the thing. I also practice elder law, and I help people get on Medi-Cal in a nursing home. And we can still do gifting in California. Other states can't. So you can actually, there's a way to get rid of your money and still qualify in a nursing home for Medi-Cal. The document, the durable power of attorney, has to have gifting provisions. It is rare that someone drafts it and allows somebody to make gifts. So because I practice in that area as well, I'm very sensitive to the idea of, wow, I want that person to be on Medi-Cal, and I want them to preserve their assets for their beneficiaries. So there's a lot that goes into all of this.
Interesting. Are there any drawbacks from a living trust? Is there this all sounds good. I mean, is there any I can't do this, from that, or man, had you not put your stuff into a trust, Tom, you could have did something else?
No
drawbacks.
No, I think what most people find is, oh God, I've got to call the insurance person. I got to call the bank and retitle the name. I think that's the hardest part for people, is retitling assets in the name of the trust.
Got you. But well worth it.
Well worth it to stay out of probate court.
So one of the big things here, and we're going to get ready to wind this down, and then I got a couple of questions that I see on the chat, is married, divorced, remarried.
Oh, thank you, Tom. Oh yeah.
How does that play?
Yeah.
Into the living trust? Because that
yes.
I put this on Instagram, and I got a lot of comments, or a lot of people direct messaging me on saying, huh? So make sure I saved one of the best for last there.
Yes.
Talk to us about that.
I sent that to you because I had that afterthought. So this is really important. Let's say you have never been married, or you're getting remarried. And let's say you already have an existing estate plan. You have a will, or you have a trust, or you have both. And then you get married and you fail to update your estate plan and say, I'm now married to the new spouse, the name. There's something called an omitted spouse statute in California that says if you don't acknowledge your spouse, it's assumed or presumed that you forgot. And that new spouse can take up to 1/2 of the estate. If there's one child, it would be 1/2. If that person, if it's second marriage and they already have kids, they might take 1/3, but that may be an unintended result. So if you remarry, or if you get married and you already have an existing will or trust, run to get it amended to say, I am now married to, I'm not providing for him or her in this trust because I've provided for him outside of the trust. It can be any reason or no reason, but you should acknowledge that you are married. It's really important.
Gotcha. You just said something and I had to write it down. You said will, trust, or a will. Can you have both?
Well, let's say you don't have a trust, you just have a will.
Okay.
And then if you have a trust, you have a pour over will.
Okay. So if I have a will right now, and then I decide to go and get a trust, that previous will no longer be valid. I will create this living trust, and within this living trust, I now have a pour over will.
That's the will that says, hey, Bank of America, Tom forgot to put that account into his trust, and I need the judge to sign an order saying, hey, Bank of America, turn it over to the trustee of Tom's trust. That's gotcha. A pour over will.
Could the people that you say forget to fund their trust, could they have that in the back of the mind that, hey, it's okay, I'm covered in the pour over will part of that? Could that be something?
No, what they're covered under is the grant and assignment and the attachment of assets to the trust. it would be rare that my clients would have to go to probate court because of the other documents. But you have to do a will when you do a trust. It would be malpractice not to do it.
Gotcha. So my last question is, do I need to own real estate to have a living trust? I mean, hey, I rent an apartment. I got 20 grand in the bank. I don't know if I'll ever buy real estate.
Maybe that person doesn't need a living trust. If we could get away without a probate, and I have clients like that, they don't own real estate, but they have bank accounts, things like that. I'll do a will. But I want to tell you that I just did a trust for someone who is doing digital artwork, and he's selling his art online. So now we have all this intellectual property.
Yeah, NFTs.
We have, what is it?
NFTs,
non-fungible tokens. So it's a whole new world of digital assets. So I created a trust for him solely with his artwork, with his digital artwork. You have to have it registered with the Copyright Office, but he's really making a lot of money right now. So that is what's in his trust.
Interesting.
His intellectual property rights.
Got you. So I've got all my questions answered. I think we've covered most anything. Barbara, do you think there's anything that I missed?
I think you covered all the bullet points, but I'm happy to answer questions.
Okay, so let's jump into questions here. The first one I have is Kelly. Kelly says, what about the sister that had joint tenancy, but then severed it and died? So half will go into probate or half will go to the other person still alive. Will she need to be the administrator? Does that make sense?
Well, if you had a joint tenancy bank account, why would it be severed? I'm curious, because if it's a joint tenancy bank account on death, it goes to the other joint tenant.
Kelly, why don't you open up, unmute yourself and kind of explain a little bit there? Do you mind?
So yeah, it's not a bank account, it's for property. They both owned a townhome.
Yeah.
Yeah, they owned a townhome, and then the sister that passed away severed the joint tenancy like 2 years ago, and I guess she didn't put it in a trust or anything. So
yeah, now you've got tenancy in common.
Yeah, so her half is going to go into probate, I'm guessing. And
absolutely, Kelly. Yes.
And so for the one that's alive, if she wants to sell the townhome, how would that work?
They'd have to go to court, and I guess you could sell it through the probate.
Sell it through probate. Okay.
So each of them owns a half. So the only thing you can probate is half.
Mm-hmm.
So what would be for sale through the probate would be an undivided 50%. And then are you a real estate agent?
Yes, ma'am.
So you could represent the other sister or the other, co-tenant.
Mm-hmm.
And so 50% would have to be probated, and then the sale would be 50% through the probate and 50% from the individual.
So is that still like a 6-month process?
Oh yeah, because is there a will?
I don't know. It didn't show
There's no way to transfer title without a court order, Kelly.
Okay.
Good question. Good question. Thanks, Kelly.
That's a tough one.
Yeah, can you imagine putting on the market? I got 50% of a property for sale. You got a bedroom and 1 bathroom,
you'd have 50% sale through the probate, and 50% would be subject to court confirmation, perhaps, unless you get Independent Estates Act, and then you don't, right?
But what if I'm the other half and I don't want to sell?
Then you don't have to. I mean, maybe you buy out the other 50%.
Gotcha. Interesting. All right. Helene, it says, is there a document that specifies the language to follow to include in my handwritten will? Does my bank account need to match my trust, i.e. Wells Fargo, name to be Helene Cornell, revocable living trust?
Well, I would say if your bank accounts are more than $166,250, you want them in the trust. Otherwise, you could have a pay on death account. You could have, if it's an investment account, it could be transfer on death. You could have named beneficiaries. It could pass by beneficiary designation on the account.
Gotcha. She said, is the $2,000, the $2,000 fee, even if I have multiple properties, I assume I have to add each additional property into the trust?
I probably would charge more because there might be more deeds. So it might be a little bit more for multiple deeds.
And how about a prenup, she says?
Oh, very important, because I have to draft to the prenup and I have to put part of the prenup language in there. Yay, glad you have one.
Yeah, I love it. Also, can I have a property in Canada? Do I need to hire someone to be like an international trust?
So I can't do deeds in other jurisdictions. So we'd have to have a lawyer up in Canada transfer the deed up there into the living trust. Doable, very doable.
Interesting. All right. Anybody else have any questions for Barbara? I think that took care of our chats. Going once, going twice.
Where can you get my information?
Yeah, where can we get your information? Barbara, that's in my closing notes, by the way. Barbara, how can people get in touch with you?
They can go to barbarabergstein.com, which is my website, and you can contact me through the website.
Perfect, perfect. And then any of you guys need to get a hold of her, you can always reach out to me as well, or my team and I will be more than happy to reach out to you and get you her information. Barbara's already taken care of our family and we're super excited and stuff like that. Barbara, thank you very much. We are about almost an hour into this. That was amazing. And I want to say thank you to Dawn. I want to say thank you to Matthew. I want to say thank you to Nadia. Without you guys, I would not have been able to put this on. Thank you to everybody who attended. I hope you guys got a lot of value on it and you guys are taking care of your clients or taking care of yourselves. And as always, stay blessed. All right, guys, we're going to end
guys.
this.
Thank everybody for attending.
All right, Nadia, shut it down.
Thanks, Tom.
Bye, guys. All right, guys, that was my interview with Barbara, estate planner. So I hope you guys got a lot of good information out there. If you need to reach out to her, make sure to direct message us. We'll be more than happy to send her information out to you, or you can visit her website. And remember us for all things real estate. All right, we'll see you on the next one. Bye.